Hi, my name's Dave Hathaway, and I'm the chair of the Litigation Department at Dean Mead Law Firm. I've been in practice around 15 years, and I have essentially three practice areas. One is commercial litigation, which is the resolution of disputes among corporations and individual business people that they can't resolve on their own. The second would be trust litigation and estate litigation, where we represent trustees, beneficiaries, personal representatives, and other family members who may be challenging either a provision of a document or how a document is being administered. Third would be intellectual property law. I have litigation concerning intellectual property, and also I file applications for the registration of federal trademarks. One of the things I like the most about my practice is mediation. I've always considered mediation to be the most important day of a case because it's the one chance that you have to put everything on the table and see if you can work out a resolution through all of the fruits of your labor that you've been through for the past months or even years. I do think that mediation is something that people need to be extremely skilled with, because the truth is probably 95% of cases don't even go to trial anymore. It seems like most, especially commercial litigation, is going to be settled either at mediation or some other time out of court. Therefore, it's really crucial to know what you're doing on a lot of different levels on that day. The funny thing about mediation is often you will not have a course on mediation in law school, and a lot of people don't take seminars or CLEs on mediation. So I think what a lot of people do is they just learn through being an associate and watching a shareholder handle mediation. And of course, all the partners and shareholders do things differently. So essentially what a person is picking up on is both the good and the bad habits of a variety of different individuals. And it's really, mediation's a little bit too important to just learn through trial and error. In addition to watching others, people may try various things at mediation. Well, if they're unsuccessful, you don't want to be doing those kinds of things at the expense of your client. It would be nice to have a lot of the principles in mind before you go for your very first mediation. So what I did was I wrote an article called 15 Tips for a Successful Mediation. It's meant for people of all skill levels, from junior associates all the way through senior partners, just to give an overall guide of practical pointers for dealing with mediation on a lot of different levels. My article, as I mentioned, is 15 tips. Each of those is a fairly lengthy paragraph, so what we did was break the article into three parts. It's a three-part series with the first, second, and third parts each comprising 5 tips. The first section is really more about how to prepare for mediation, what things to be thinking about, how to prepare a good summary for the mediator, ethical issues, and a number of other topics, such as thinking about bargaining points, thinking about the relationship between the participants to the mediation and the money, and a lot of things like that. Then the second section is more about the mediation itself. What happens when you get there? What kind of opening statement? Who should make the first offer and at what number? How should you counter bad behavior from the opposing counsel? And then the third part of the article is really about, it gets late in the day. Should you ever pass your reserve point? What kinds of things should be done when drafting a settlement agreement? And even how do you keep mediation in perspective at the end of the day? So I do invite you to read the article. I hope it's helpful. If you'd like to contact me about my article or litigation in general, call me at my direct dial number, which is 407-428-5124, or email me at Hathaway, that's first initial, last name, at deanmead.com. Thank you.